All right, court is calling 2022 CR 2397 State of Texas versus Wilfredo Salgado Salinas. Can I have parties announced for the record for the state?
Daniel Escobar for the state.
Stephanie Collins for the defense.
And are you Mr. Salinas?
See.
Yes.
All right, we have an interpreter with us. If you can raise your right hand for me, please. Do you solemnly swear or affirm that you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Arlene Abrams, license number 2081.
All right, so the first thing, my understanding is that he is requesting a jury trial. Is that correct?
Judge, before we reach that matter, I would like to ask the court to ensure that Mr. Salinas is desiring us to represent him. I know this was a question before, but before we proceed to jury trial, I think I need to put it on the record again if he wants us to represent him or not.
Oh, well, what I can tell everyone, this is an old case. I know that your firm was wanting to withdraw, and that motion was filed and the court denied it. And if he wants another attorney and does not want you to represent him, then he needs to have an attorney who's prepared for trial tomorrow, because this specific case will be going to trial tomorrow.
Judge, he has been trying to fire us for 2 months.
Mhm.
And we did not attempt to withdraw on our own request. We attempted to withdraw because he asked us to, and he's been asking the court to appoint him an attorney since July 20.
No, he has not.
Those motions are in the file.
No, he has not been asking for this court to appoint him an attorney. And
Is that
if my understanding is, one, you have not been the attorney who's been on this case. There's been another attorney from your firm. And where is that attorney? Because
Judge,
that's the
he's
attorney.
resigned.
No, that attorney needs to be here because he's listed as his attorney.
Anthony Wilson, or is that who you're speaking of?
No,
Judge?
I'm speaking
Carlos
of,
Ramirez?
yes, where is he?
I'm not sure. I think he is down taking care of other business.
He needs to come up here and take care of this business.
Okay, but Judge, I did see in Odyssey that there's been some pro se motions filed requesting an appointed attorney.
Let me just explain to everybody how pro se motions work. When somebody has retained counsel, their pretrial motions are not heard by the court.
Of
Their
course,
pretrial motions are only heard if they are pro se. He is not pro se. And Carlos Ramirez, who has been here, needs to be here. He knew that this was here,
sure.
so I do not understand why he's not present.
Okay, but the issue that we need to determine is if he, just for the sake of trial, and I understand, Judge, that you're gonna call this case tomorrow regardless, but for his sake and ours, I need to put on the record if he is wanting us to represent him at trial.
All right, so what I'm telling you is the person to be asked those questions and to put it on the record is Carlos Ramirez, not you.
Well, I am also listed as attorney of record, Judge.
Well, I'll have them check to see if that's the case. Ms. Ferguson, can you look and see if she's listed as an attorney of record? Or is it just their firm?
Judge, I see Carlos Ramirez, Stephanie Collins, Anthony Wilson, all listed as his,
And are you Stephanie?
Yes.
All right, ask your questions.
Mr. Salinas Salgado, before this goes on, Judge, I would also object to this being broadcast on YouTube in the event that potential jurors are watching this right now, knowing that they're gonna be called to this court tomorrow.
Mhm.
I think that would be prejudicial, Judge.
All right, your objection is overruled. Do you have questions for him?
And I would object to the overrulement for the record. Mr. Salinas.
Just a moment. So this is how things work. You make your objections, I make a ruling. There is no, I object to the court's ruling. The court's ruling is the court's ruling. And if you're intending to preserve error, how you preserve error is you make a request, I make a ruling. That's your error. It's preserved. Preserving your error is not if I overrule an objection or I sustain an objection and you say, well, I'm objecting to your overruling or sustaining an objection. Legally, that's not how things work. So your objection to the broadcast is overruled. Now, here's my question. Is he going, if he were to be found guilty, is he going to the court for punishment or is he going to the jury for punishment?
We have filed a motion for jury, but I still need to determine if he wants us to represent him or not.
All right, so this is what I need you to do. I need you to listen to my questions, answer my questions, and we will go in the order that I'm giving you. So, Mr. Salinas, do you understand this process? Have they explained to you about jury trial? Well, let me strike that question. Don't answer that question. Let me explain to you. In this court, since you've been here, this is the process for this court. First thing that happens is I make sure that defense attorneys have all of the discovery. What is discovery? Discovery is items or evidence or proposed evidence about your case. So if there's a video that's about your case, the defense is entitled to have that. And I make sure that they have that. And if it's something that they say they don't have or something that they think they should have, and maybe the state has and hasn't turned it over to them, I'll make sure that they have that. So in your case, your attorney has said they have all of the discovery. So that means that all of the evidence that you're entitled to, they have that. Your attorney, Mr. Ramirez, has said that's the case. Then the next thing I do is I tell the state in this court that you have to tender an offer. That offer will be given to your attorney. That attorney will go over that offer with you. And then if there's something you don't understand about the offer, then you're to ask your counsel. Do you understand?
See,
Okay.
Yes.
So yes or no, has an offer been tendered to you in this case?
no,
No.
All right, so this is what we're gonna do. I'm gonna have you sit down. The state will let this defense attorney know, because I know this defense attorney hasn't been here. It's been Carlos Ramirez. The state will let them know what the offer is. And then your attorney, who's here today, will let you know what the state's offer is. Then you will let me know whether or not you're accepting the state's offer or whether or not you wish to go to jury trial. Do you understand?
see,
Yes.
All right. If you do not reach an agreement, this will be going to jury trial. And what that means is a jury will be in the hallway at 10 o'clock. And then we will start jury selection. But the first step, the state is going to give the attorney here what their offer is to you. And then you will come back and let me know whether or not you're accepting that offer. Do you understand?
Yes, okay.
Okay, thank you. We're off the record. How do you say okay in Spanish?
Okay.
Okay, all right. See, usually.
It's
No, no, no.
fine.
All right, we're back on the record in 2022 CR 2397. And the interpreter is present, but could I have parties re-announced for the record? State,
Andrew Harris Edelman.
defense?
Stephanie Collins.
All right, so first things first. Mr. Salinas? Did you receive the offer from the state?
see,
Yes.
All right, did you understand the offer?
see,
Yes.
All right, so knowing what the state's offer is, were you able to reach an agreement with them or no?
no,
No.
All right, are you asking for a jury trial?
see,
Yes.
All right. And state, did you want to place the offer on the record?
Yes, Your Honor.
Yes.
All right, and then we have pretrial motions.
We do, Judge.
All right, the first one, I don't understand the issues you all have been having with the clothing exchange. Because my understanding with the clothing exchange here in Bear County, unless it has changed recently, what needs to happen is if the attorney is not the one who's bringing the clothing, if it's going to be a relative, then there needs to be a letter attached to it so that the jail will know that this relative is bringing clothing and when his jury trial is. So has that been solved?
Yes, Judge.
Okay.
We figured that out. I think there was just a misunderstanding of what exactly the judge or the jail wanted. Because I think Carlos's understanding was they were asking for an order, but I think we got that worked out with the help of another defense attorney.
Okay, awesome.
Great.
All right, then the next thing is him appearing in personal clothing and without restraints. What I can tell you, the deputies are in charge of security. They don't bring anybody over in handcuffs for the jury, but he will have on a leg brace.
Okay.
So is there an issue with the leg brace?
Judge, from what I understand, and the deputies can clarify if I'm incorrect, the leg brace cannot be seen under pants. And so as long as it cannot be seen, and it's not visible, then we have no problem with that.
Well, I mean, they have the leg brace in the back, and what I can tell you is the leg braces are not seen when someone's wearing pants.
Perfect.
All right. Now, the next thing is all right, is there another motion besides that motion? Let me see, just one moment. Here we are. All right, motion to voir dire expert witnesses. All you have to do is request that whenever the state is going to call an expert witness. This is a aggravated assault with a deadly weapon. State, are you calling any expert witnesses or?
As far as I'm aware, Your Honor, no, we are not.
All right. Well, if you intend to call an expert witness, just let the court know and you can voir dire the witness outside the presence of the jury.
Thanks, Judge.
And then we have a motion in limine. What I can tell you is with regards to motion in limine, you can always approach on these.
Okay.
Many times I don't know the facts of the case until I know the facts of the case. So if there's an issue with priors, if the state is seeking to introduce 404B, state just approach before you get into anything of that nature.
Yes, Your Honor, and I apologize for interrupting, but there is additional information that I would like to add.
Yes.
ADA Escobar filed a notice of state's witness list, and on that witness list, ADA Escobar listed the following as expert witnesses. Officer M. Prado, CSI Kimberly Wong, Detective James Hankinson, and Detective Daniel Caraco, all of SAPD. I do not know what, if any, domain their expertise would be in, Your Honor.
All right, then you'll have to lay the foundation if they're being offered as expert witness. And then what subject matter are they an expert in? And then I'll excuse the jury. And then if you have questions for them that pertains to their expertise, then we will have a hearing on that outside the presence of the jury.
Thank you, Judge.
Understood, Your Honor. Thank you.
Right. And I'm reading through your motion in limine. All right, some of these motion in limines, I believe that this would just require an objection at the time. For example, if you think that the state during voir dire is committing a juror to specific facts of the case, then you'll need to object and the court will make a ruling on that.
Understood, Judge.
Reputation or character, state approach on that.
Yes, Your Honor.
Specific instances of conduct that are outside the presence of this case. For example, if the specific instance of conduct you are speaking of is conduct that relates to the aggravated assault with a deadly weapon, then that comes in. But if you're speaking to specific instances of conduct that are unrelated to the aggravated assault with a deadly weapon, then you all need to approach before you go into that.
So, Your Honor, if there is an extraneous offense that arises out of the same criminal episode for which the defense already has notice, we do not need to ask the court's permission to ask questions to witnesses about that.
Well, it is hard for me to know whether that's appropriate or not without hearing the facts. Just approach and I'll make a ruling on it. But it appears to the court that if there are facts in this case where there is one continuance alleged offense, that would be admissible. But from what I'm reading in your motion in limine, it appears that you may be asking for something unrelated to the facts of this case. Is that correct?
Correct, Judge. If there are, I would also ask that if there are extraneous offenses that occurred at the same time, but were unrelated to the ongoing episode as charged. I can't think of an example of these facts, but I could think of some random example, like a theft of a car and that has nothing really to do with the aggravated assault, if like something like that, even though it occurred sort of simultaneously. We would ask the state to approach on something like that.
All right, state, just approach.
Understood, Your Honor.
All right, and then audio recordings of any witness for the defendant for impeachment purposes. All right, if it's an audio recording of your client, then you'll have to make whatever objections you deem appropriate at that time, and I will hear those objections. All right, and was there any type of offers or negotiations to pay medical and similar expenses and liability insurance in this case?
None that I'm aware of, Your Honor.
All right, if there is, approach before you bring that up. And remedial measures after.
Judge, I would say something like, offer to pay, an apology, anything like that. I don't think that there was that as far as I know, but if the state, is going to elicit that from a witness, or if they anticipate a witness saying that based on, anything they know now or anything they find out, then I would ask them to approach on that.
All right, so state, if there were any statements made by Mr. Salinas, have you already turned those statements over to the defense?
To the best of my knowledge, yes, Your Honor.
All right, so if you believe that there is something that a witness is going to say, a statement that your client has made that you're unaware of, then just object. We'll approach and I'll have a hearing outside the presence of the jury.
Thank you, Judge.
And we've already addressed the expert witness testimony. All right, let me ask you this. With regards to defense's motion in limine, did you all have a chance to review the defense's motion in limine?
Yes, Your Honor.
All right, is there any of this that you all have agreed on?
Judge,
Don't believe we conferred on any of it, Your Honor.
I did confer with, Mr. Escobar, I believe, and I don't think we had did the state have any objections?
Judge, I think we specifically talked about a couple points on the motion limiting. I don't think we talked about all of it.
Okay.
All right, so let's do this. Number 15, state, you're not allowed to define reasonable doubt because there's no objection. I mean, there's no definition for reasonable doubt. So that will be granted.
Thank you.
Speaking objections. Here's the thing, I don't allow speaking objections, but if you believe somebody is making a speaking objection, object to
Okay.
speaking objection. Number 13, approach. Number 12, would you like to explain number 12 to the court?
Judge, I don't have
It's-
it in front of me, but
Any evidence, testimony, inquiry, or reference either directly or indirectly relating to any argument, statement, or reference in the jury's presence by the state, comparing the facts, evidence, procedural circumstances, or competence of investigation of the instant case with any other legal proceedings in cases unrelated to this cause, or eliciting jurors' feelings, reactions, or opinion about such.
I think it's more appropriate and to limit that to the actual case in chief, as like arguments in opening statement or arguments in closing statement about, think of the OJ case or think of, the Johnny Depp case, like think of like how that happened and compare it to, something they heard here.
All right, State, are you intending to compare this case to some other case?
Not in the way that defense counsel describes. However, there are aspects of the response by SAPD in this case that may be compared to other general responses in other cases.
All right, just approach.
Okay.
Expert testimony,
We'll-
yes. Approach,
And ask the court to
excuse the jury if,
excuse the jury and assert its gatekeeping function before allowing any expert testimony from any deemed expert witnesses, Your Honor.
yes. Number 10, approach. Number 9, they're saying there isn't any,
Okay.
but approach.
And
If there
Your
is-
Honor, if we learn of any between now and and when the proceedings actually commence, we will inform defense counsel as quickly as we can.
All right. All right, with, as far as audio recordings, any attempt by the state to introduce audio recordings of any witness for the defendant for impeachment purposes or for any other purpose without proper, oh, you're asking that the records be authenticated?
Yes, Judge.
All right, state number 8, you'll have to lay the foundation.
Understood, Your Honor.
So I think though that's, you object to it if you deem they didn't lay the foundation.
Of course, Judge.
And we've already addressed 7, we've addressed 6. We've addressed 5. 4, you'll need to object. That's commitment questions to the jurors. Number 3 is also commitment question. You'll need to object. All right. Now, defendant's request for notice. They want 404B. Is there any 404B?
I believe you've turned it over to us, is that correct?
Sure hope we have.
All right. And then the next thing is discovery.
Right, Judge. And I do believe the state has proffered that they've given us everything that they have in their possession. If they have not, I would ask that they do that before the trial commences. And if they have anything that they find during the course of the trial, that they turn that over to us, regardless of what it is and what they've deemed the significance of it is.
Yes.
Yes, Your Honor. And as far as I'm aware, there are no other crimes, wrongs, or acts, prior convictions which the state will seek to introduce that arise out of an offense that arises outside of this instant offense.
Okay. All right. And then with regards to discovery, if there's something that you discover during trial that you were entitled to and the state has not given you, then make the appropriate objections, and then I will make a ruling on whether or not it's admissible or not, or if there's a mistrial or whatever else is needed to remedy that situation.
Thank you.
All right, is there anything else?
No, to the preliminary issue that I wanted the court to address, I have confirmed with my client, and without revealing any privileged information, I do believe we've clarified that.
Okay, all right. All right, so then what will end up happening, they have to qualify the juries tomorrow.
Okay.
And that usually takes some time.
Sure.
So we'll start with voir dire. I'm gonna say everyone be here at 9:30, but the jury will probably be up here at 10.
Okay. And Judge, do you all do jury questionnaires in Bear County? No?
Not for this level of felony.
Okay,
Yes.
okay. So is there a list or anything?
Yes, you'll get a list tomorrow.
Okay,
And of course, it'll be the standard juror card that's been filled out for them. But as far as jury questionnaires, that's not done on this level felony
okay, okay, I understand. Judge.
unless requested.
Okay, all right.
Okay.
Thank you, Judge.
You're welcome. Is there anything else?
I don't believe so. We did file our election of punishment. He does want to go to the jury. And then we will file a sworn motion requesting probation or application for probation as well.
All right. Oh,
Before
you
the
can,
jury is called.
oh, you all can do that now.
Okay,
Yes. And
do you have
I,
a favorite one?
yes.
Oh, okay.
All right. Is there anything else?
I don't believe so, Judge. Oh. How does the court wish us to address Anthony Wilson being an attorney of record? Because he is no longer with our firm. He is not respondent to any communications from our firm except to provide his resignation.
Well,
And so,
that's, I mean, the jury is not gonna know that
Okay.
Anthony Wilson was previously at your firm or was an attorney unless y'all
course.
want to tell the jurors that.
I just, for the purposes of the record, I don't know if the court had any concern about him continuing to be listed, but,
No, I mean, because the person they have listed now is Carlos Ramirez.
okay, great. All right. Thank you, Judge.
All right, you're welcome.
Are we excused, Your Honor?
State your excuse, but she still needs you for a moment so they can have him fill out the fill out his election for punishment and also swear on the never been convicted of a felony before.
Thank you, Your Honor.
All right, thank you.
Te van a hacer unas preguntas. So is the trial starting tomorrow, Judge?
Yes. And so we'll start with jury selection.
They can
I'm
call
not sure
for
if the jury will probably be up here at 9:45. We probably won't be able to start before 10.
Okay, they can call and see.
Okay.
All right.
All
Okay,
right,
let
thank
them
you
know.
so much.
You're welcome.
So he actually needs to sign this.
Tiene que firmar eso.
So basically what we're